From 22nd July 2025, the Home Office will refuse new entry clearance applications that rely on Standard Occupational Classification Code 6135 care workers and home carers or 6136 senior care workers. So sponsors can no longer recruit frontline carer directly from overseas. Now, where these rules are coming from? They are coming from the policy paper Statement of Change, which was published on 1st July 2025. Someone recently mentioned this, that the applicants who are in the country on care worker visa, they need to leave the UK in 2026, etc. So I thought to provide you the clear guidance from Statement of Changes immigration rules, that what it says and what will happen in the transition period. Transitional arrangements will operate until 22nd July 2028. So currently we are in 2025. So 2025 to 2026, 2026 to 2027, from 27 to 28. That's 3 years. Sponsored care workers already in the UK can move into or remain in a 6135 6136 post, provided they have been lawfully employed by the same sponsor for at least 3 months before the new COS is issued. So if you are on a graduate visa, you can switch to 6135 6136 if you are already in the UK. If you are outside the UK, you are not allowed to come after 22nd July 2028. Further, it says the same 3-month rule applies to changes of sponsor within the sector. Care providers in England must also continue to hold up-to-date CQC registration throughout this period. After the 2028 cutoff date, the codes will be removed from both the immigration salary list and temporarily shortage list, ending sponsorship entirely. Now the question mark is, what if your visa is valid until 2029? Now why am I creating this video is because many healthcare worker visas who switch from student visa on a new entrant route, they got 4 years visa and their visa is valid until 2029 or 2030. So what will be your case? In that case, since you already have a valid skilled worker visa under code 6135, but it getting expired, for example 2029, you fall within these transitional provisions because your visa was granted under the old rules before or during the transition. You can continue working in the UK under that visa until it expires. The removal of the occupation code after 2028 does not automatically cut short visa already granted. In other words, your right to stay up to 2029 remains intact as long as you comply with your visa conditions. For example, work for your sponsor, minimum salary requirement, and other conditions which you have, your permission will be valid. So this statement that after the 2028 cutoff date, which is 22 July 2028, the codes will be removed from both the immigration salary list and temporary shortage list. Ending sponsorship entirely means that no one else can come on this visa, can come on 6135 or 6136 job code. Anyone who's already on that visa or switch or remain on that visa before this 22nd July 2028, it's fine. So for example, next year in 2027, 22nd July 2000 or 1st of July 2027, you wanted to apply healthcare worker visa and you wanted to switch from graduate visa to this visa, you are allowed to do so. But after the cutoff date, no one will be allowed. That's what it means. Now next question is, can I switch? I'm on a student visa and I wanted to switch to as a carer on 6135 or 6136. So the company don't need to pay ISC. Okay, so as per new rule from 22nd July 2025, you are not allowed to switch. So this is what it means, that you are not allowed to switch directly into the care worker in this 6135 or 6136 code. You can only switch if you work at least 3 months. So if we try to understand this, sponsorship as care worker will not be possible for new entrants to the route from 22nd July 2025, because new entrant obviously has not worked in this route. But if you are on a graduate visa and you working in the care sector for more than 3 months, then you can switch. Further, it says with the policy context stating concern over workers sponsored as care worker and senior care worker occupation code 6135 6136 are well known. However, for those already in the UK and working for their sponsor for at least 3 months prior to their CUS is being issued. Now, one more thing before I go forward, for their sponsor it says. So if you are working for one company and that company don't have the CQC license, and then another company trying to hire you and giving you the visa, they can't, because you have to work minimum 3 months for that new sponsor if you are on a graduate visa. However, for those already in the UK and working for their sponsor for at least 3 months prior to their CUS being issued, it is possible to switch from other visa routes. Other visa routes, graduate visa, can't be student visa, because obviously if you are on a student visa, you're not allowed to work full time anyway, to continue for a transition period until 22nd July 2028, at which point these occupations will be removed from the immigration salary list or temporary shortage list. So if we go back to statement of changes immigration rules, on this guidance, if you go down, you have the list. So this is the list we are talking about, temporary shortage list. And so the code will be removed from both the list. So if we go down over here and if we try to read this, if the applicant is being sponsored in the SOC 2020 occupation code 6135 care worker and home carer or 6136 senior care workers, the application must be for permission to stay, and either number A, number B, the application must have been legally working for the sponsor in one of these SOC occupation code for at least 3 months ending on the date the certificate of sponsorship was issued by the sponsor, and the applicant, the date of the application must be before 22nd July 2028. Now this clearly states, so before that date you can assign, after that date you can't assign. So even in 2027 you can assign this. There's a lot of confusion that after this date people have to leave, they have to like anyone in the UK who already got the permission, they have to leave. So that's why there is a clearance and there is a proper guidance, and that's what we need to read. We should not follow anyone, we should only follow what gov.uk says. All my content is from gov.uk. Now point B, the applicant must have permission as a skilled worker sponsored in either of these SOC 2020 occupation code or the SOC 2010 occupation codes 6145 6146, except that where paragraph 39E applies, that period of overstaying will be disregarded. Now further it says, if SW 6.1b applies and the applicant was previously granted permission as skilled worker sponsored in SOC 2010 occupation code 6145 care worker and home carer 6146 senior care workers under the rules in force before 11 March 2024, and B since then has continuously had permission as a skilled worker sponsored in either or both these SOC occupation code or SOC 2020 occupation code 6135 6136. Point C is applying to continue working with the same sponsor as in their most recent grant of permission. The Care Quality Commission regulation requirement for these occupation code does not apply